Your home is supposed to be your castle. But what about the land your castle sits on? I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. Our guest today is Josh Windham, an IJ attorney and co-director of IJ's Project on the Fourth Amendment. We discuss why most private land in America gets no protection from warrantless government surveillance. This is Beyond the Brief. So why is it that most land in America doesn't get protection against warrantless searches? Isn't the Fourth Amendment supposed to do that?
I think that's what most people think. If you take the average person on the street and you ask them, does the government need a warrant to search your property or to seize your property? They will say yes. Isn't that what the Fourth Amendment's all about? Isn't this America, right? Unfortunately, 100 years ago, almost exactly 100 years ago, the U.S. Supreme Court made a grave mistake in a decision called Hester, where they held that so-called open fields, which really means the vast majority of land people own in this country, is entirely unprotected by the Fourth Amendment.
Before we go on to unpack Hester and some of the subsequent cases, I was wondering if there's some way to quantify how much land falls under this open fields exception, because, I was raised in a suburban home. The nearest thing to an open field that I've seen since moving to D.C. is checking out a winery in Leesburg. So the open field concept may be foreign to a lot of folks. How prevalent is it for land to fall within this gaping exception to the Fourth Amendment?
Yeah, I think to understand that, we have to understand, what qualifies as an open field, right? And so in the line of cases that I'm sure we'll talk about today, the Supreme Court has articulated a concept called the curtilage. And the curtilage is really just this small ring of land around your house. So if you walk around the area we're all in today, Ballston in Virginia, you'll see that houses all have kind of a small fenced in yard, right? That's typically going to be considered protected curtilage. And the idea there is that that area is sort of part of the house for Fourth Amendment purposes. But all other land you own anywhere is considered an open field, regardless of whether you fenced it, regardless of whether you have no trespassing signs up, regardless of whether you're using it for economic or personal purposes. None of that matters. If it's outside this small ring of land, it's not protected. And today, IJ released a study, which we published in Cato's Regulation magazine, where for the first time ever, we were able to quantify the real-world impact of the open fields doctrine. And we found that about 96% of all private land in the country, or about 1.2 billion acres, is entirely unprotected by the Fourth Amendment under current law.
I know you mentioned Hester as a mistake. What do you think led the Supreme Court to carve out that exception? I understand that there were some contextual issues at the time that the court was wrestling with, and I think they wrestled with them again, some 60 years later in the 80s. What was going on? What was the court trying to do when they created this doctrine in the first place?
Well, it was a case about moonshine. And so, there was sort of a rising fervor at the time about cracking down on alcohol. And this is a few years before Prohibition formally, comes down. But they were federal revenue agents, and they were there to see if they could find untaxed alcohol at the time. So this is sort of the pre-Prohibition era. But it is really a case that is a creature of the Prohibition mentality, that if you have a forbidden substance on your property, the police need to get in and find that and root it out, right? And if that's the mentality that we give our government officials, that, their job is to root out forbidden substances in people's homes or properties, they're going to go rooting around those homes and properties, right? But in terms of how we got the legal outcome in the case, it's kind of astonishing. If anyone watching this can go read the Hester decision, because it is 2 paragraphs long. And the operative part of the decision, the part that actually produces the legal result, is 2 sentences long. And what the court essentially says is, and I am almost quoting here for you, the special protection accorded by the Fourth Amendment to the people and their persons, houses, papers, and effects is not extended to the open fields. And then the court goes on to say, the distinction between the house and the open field is as old as the common law. Now, we can break that down a little bit, and I just want to make 2 points about it. First of all, this is not how we're supposed to be reading constitutional provisions. What the court does is it pulls 5 of the Fourth Amendment's 54 words out of the Fourth Amendment, says these 5 words are all we need to know about the Fourth Amendment, and then treats them, that list of persons, houses, papers, effects, as an exhaustive list of everything that's protected by the Fourth Amendment. Just to give you kind of another example, that is not how we read the First Amendment, right? The First Amendment says you have the right to freedom of speech and that Congress can't violate that right. Well, we apply it to the executive branch, right? Because the executive can violate your free speech rights in precisely the same way that Congress could. And we apply it to all sorts of things that are not like just verbal utterances, right? If you go to the original meaning of speech, it means words coming out of your mouth, right? But of course, the First Amendment protects a whole line of conduct from like marching with particular armbands to nude dancing to art to burning flags to staying silent. All of these things are not speech in the literal sense of that word, but they are nevertheless expressive. And the court says, look, we're going to treat that as sort of the principle behind the First Amendment and extend its umbrella broadly. And we could and should do the same thing with the Fourth Amendment.
So if this analysis in Hester is such a, aberration is maybe not the right word, but it seems kind of,
it's the right word.
Okay. All right. It's an anomaly. It's weird. How has it lasted for 100 years?
Well, I think there's a couple things to say about that. One, in the cases where this issue has come up, and I think Keith was alluding to this a second ago, it's been kind of like parts of the same story. So the original case, Hester from 1924, was about essentially prohibition before prohibition. And the second case that addressed this issue was called Oliver in 1984. So 60 years later, that was about America's second war on drugs. It was about marijuana. And so there's a kind of massive incentive swirling around the court at the time to grease the wheels for law enforcement and to kind of like ride with the cultural tide, right? And so that is, I think, part of what's motivating the court in these cases is to ensure that police officers can find these forbidden substances in people's properties with ease, right? The other thing I'll say is that the court has bounced back and forth between different ways of reading the Fourth Amendment. Early on, it applied this kind of hyper or strict textualist approach where we just treat like the literal text read as narrowly as possible as all we need to know. The court kind of bounced away from that in the mid-20th century, and we can talk about that trend if you want, but the court has shifted back again towards looking at the text, reading it kind of narrowly, and that's what we get in cases like, for those who are interested, Jones, Hardiness, and stuff like that.
So far, I know we've been talking a lot about federal cases and interpretations of the federal Fourth Amendment. As I'm sure you know, right, there are also state constitutions with state Fourth Amendment analog provisions. Do states uniformly follow the Supreme Court with this open fields doctrine? Is there any divergence? Are some states more protective than others, or is it more or less a carbon copy of how the federal courts have treated the Fourth Amendment so far?
To our knowledge, there are 7 states that have rejected the federal open fields doctrine under their state constitutions, and they do it for all sorts of reasons. So sometimes there's a very clear textual hook that courts will use and rely on and say, look, the Supreme Court has said it really matters that the Fourth Amendment protects persons, houses, papers, and effects, but it looks like our Constitution has some different wording in there, right? So Tennessee, where we're litigating and had a great trial court victory about a year and a half ago, and we're hoping for a Court of Appeals victory soon. In Tennessee, they have persons, houses, papers, and possessions. And if we know anything about the word possessions going back to the founding, it's a concept that applies to land and real property. Other states have right to privacy clauses. Louisiana, where we filed a case about a week and a half ago, they have an even clearer provision. Article 1, Section 5 of the Louisiana Constitution protects property. And land is property, right? So it's kind of a dealer's choice. You can go state to state and find all these different constitutions, but there are some states like New York that have identical text to the Fourth Amendment, and they just say, look, we think the Supreme Court got it wrong, and we're going to take our own approach.
You mentioned a few different cases just now, and this might be a good opportunity to pivot and talk about how the open fields doctrine is affecting everyday Americans. Because, as you mentioned, in the beginning, the open fields doctrine primarily was involved in, drug-type cases, but clearly today it has a much broader scope. So how is this impacting IJ's clients, for example?
Well, I mean, let's talk about our Virginia open fields case, because it's one that I think a lot of folks might be able to relate to. So our client, Josh Highlander, bought a property on a secluded residential street in Providence Forge, Virginia. I think he bought about 30 acres. And if you drive down this street, as we did when we first met him, you see like fences on the left and right. You see mailboxes lining the street. You drive past his parents' house, which is 2 houses down, and he buys this lot at the end of this gravel road. And the lot is a place where he builds a house, He kind of clears a little area of the forest there, and he thinks, like, this is going to be a great private, secluded spot next to my family, next to our friends, where we can raise a family in peace and solitude, and the kids can play in nature, and I can do a little hunting too, because I have 30 acres, right? So that's the vision for the house. And so he builds it. They have 2 little kids. And last year, he was in the shower, and his little son, about 5 or 6 years old, and his wife were playing out in the yard. They were playing basketball on the basketball hoop next to the trampoline. So it's sort of idyllic thing you can picture, right? And, someone drops the ball or it bounces away. It rolls towards the edge of the woods. And his wife goes to go pick it up. And when she looks up, she sees a strange man in the woods wearing camouflage, staring at them. So Mr. Highlander's wife and son run into the house screaming. A strange man is on the property. His son is screaming about the boogeyman and is afraid to go out for weeks and weeks because there might be a guy in the wood watching us, right? But Josh goes out, walks around the property, doesn't see anybody until he goes out to his field where he notices something odd. He had a camera on a pole in the middle of a field where he plants crops on the property, and the camera was missing. So he goes to the sheriff. He calls the sheriff and he says, "I want to report stolen property. There was a strange man on the property. They took my camera." And the sheriff calls him back the next day and says, "Sir, your camera wasn't stolen. It's in the possession of the department of the game department, the wildlife department, and they have the camera. It's theirs now, and they're going to do with it what they will." And so what we come to find out is that all of this was basically a kind of sting operation. Earlier that day, Josh's brother, 1 county over, was cited for an alleged hunting violation. So I guess guilt by association. These 3 game wardens come to the cul-de-sac behind his house. They step out of their trucks, and we have somebody actually saw them doing this, and put on full camouflage gear and kind of like conducted a sting operation. They walked through the back of his property. They walked past all his no trespassing signs, and they spread out until they could find what they could see, right? Looking for evidence that he was doing anything wrong. And they find a camera, and they think to themselves, man, if we take this camera, maybe we can look back through all the photos and kind of like try to find evidence that in the past at some point, maybe he committed a violation. And here we are. They didn't have a warrant for any of that. They didn't have probable cause. And so this case we filed in Virginia is all about whether the Virginia Constitution allows that kind of fishing expedition on private land.
Because they didn't suspect him of anything, right? If they suspected of something, they could have just gotten a warrant. This is literally just, we're going to dig around through stuff in case we find something.
Yeah. They were there to see what they could see, right? Maybe we'll catch him doing something wrong if we're on the property, if we have proximity to him, if we can pour through his camera, right? If they had probable cause, they could have just gotten a warrant to go on the property, as police officers do when they want to enter your house or your curtilage, for example. But I think this case gets at, and the open fields doctrine issue gets at, like a broader historical point, which is the Fourth Amendment was adopted, and state constitutional provisions like it were adopted in response to a particular historical problem. Before the founding, government officials were using what were called general warrants to invade and search people's property. And a general warrant you can think of as sort of like a hall pass or a blank check to kind of do whatever you want to somebody. So if you were the officer, you didn't have to have probable cause to get a general warrant. And if it was issued to you, it didn't place any constraints on the timing, the frequency, the duration of the search. And so really it was like, go find out if Joe Schmo, or go find out if someone's violating the law in this area, right? And that gave the authority to search every house on the row and root around their chests and drawers and see what you can find. And these are fishing expeditions, right? And the whole point of the Fourth Amendment is to take that discretionary search power that made every officer a law unto himself, right? To take that power and put it under neutral and objective control, right? And so the point of requiring a warrant issued by a neutral judge is the judge gets to decide if you have probable cause to go onto someone's property. And the judge gets to say, here are going to be the parameters of the search. You can only look in these places for this sort of thing, right? And so what's wrong with the open fields doctrine? It's the opposite of that. It is the embodiment of a general warrant, but it's enshrined in constitutional law.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
One of the things that's creepiest to me about how some of these IJ cases are playing out is, you mentioned them taking Josh's camera, and the way that technology works now, officers have even more tools at their disposal, right? Like, even if they have, theoretically this general warrant that lets them, go on your land every day or whatever, they can do so much more if they have a camera that they can put on your land, or they can take your camera that's on your land, right? There's cameras involved in other IJ cases. Do you want to talk about some of that a little?
Yeah, I mean, I think that what you're getting at is the idea that if you give them an inch, they'll take a mile, right? And so in 1924, when we got the original open fields case, like, just to kind of give you the facts of that for a second before we talk about cameras, and this is not in the opinion. I had to go read the trial court transcript and the testimony of the officers to learn this, because it doesn't show up in the Supreme Court opinion. But what happened was the officers got a tip that this guy Hester had alcohol on the property. So they drive up to the property, they creep over to a grove on the property, and they hide out in the grove, and they're behind a fence, and they decide eventually, okay, let's jump over this fence. So they jump the fence, and at the moment they jump over the fence, they see Hester hand somebody a bottle. And they're like, that must be the alcohol, the whiskey, right? And so they chase him, they arrest him, shots are fired, it's dangerous, he's arrested, and they prosecute him, and he files a motion to suppress, and he loses the case. All right, so that case involved boots on the ground, right? Officers walking on in and seeing something with their eyes, which requires manpower, and they have limited resources to do that. If you can install a camera on someone's property, or use a drone to do the same thing, for example, right? You're taking this hole that was poked in the Fourth Amendment 100 years ago, and you're dramatically expanding what officers can do with that hole, right? You're blowing it up. And so we can talk about a few of the cameras. Our first open fields case was filed in Tennessee. We learned about that case because our clients, Hunter Hollingsworth and Terry Rainwaters, found cameras on their properties, which freaked them out, right? Hunter found a camera on his farm that was hanging from a tree. It was actually tied to a tree, staring out at him. I wish I had a prop here, because I just gave a talk yesterday where I had physical copies of the photos, and there's one of the photos is one of the officers in full camouflage coming to check on the camera, and he's staring up into the camera, and it's just the creepiest thing you've ever seen, right? It's really kind of ominous. But anyway, so Hunter found the camera, he took it home, didn't know who owned it, and the police raided his house and accused him of stealing government property. Terry found 2 cameras on his property. While he was riding through with his son. They were hanging from fishing lines in his trees, and one of them was pointed at the back of one of his tenants' houses on the property. The next day, the cameras were gone. So game wardens must have been aware that they saw the cameras, spotted where the cameras were, and came and retrieved them before Terry and his son could do anything about it. Who knows how long those cameras were up, right? Hunter's camera was up for a couple months, took hundreds of photos. Josh's camera, obviously, in Virginia was stolen from his property. And then in our Pennsylvania open fields case, which is at the Pennsylvania Supreme Court right now, we represent a couple hunting clubs. And they've got a bunch of members and thousands of acres of land up there in northern Pennsylvania. And in neither of these cases, neither of these clubs, were we aware that there were cameras on the property. It was only after we filed the case and sent the government a request for admission to say, admit that you put a camera on my client's property, right? Because we knew the government does this in other cases. And they came back with our client, Punxsutawney Hunting Club, and said, yeah, we admit it. And we got records from the camera installation. The camera was up for a few weeks, took a lot of photos of members walking by, trucks driving by, the property itself. Super creepy. Members were outraged when they learned this, right? They were astonished to learn the government had put a spy camera on their private land, on their sanctuary, and spied on them.
What are they even looking for? Okay, so you have these cameras, you see that people are coming in and going, so what, right? It's not illegal to come on to your own property. What are they even fishing for?
Well, I'll tell you that in the Pennsylvania case, the explanation we got for why they put the camera was there was that they wanted to see if members were feeding elk. So 24/7 surveillance by a motion-activated camera installed on private property with, almost 100 members is justified because we want to see if you're feeding animals. And, it's legal to feed deer in Pennsylvania. And so the concern was if they're putting out feed for deer, the elk might be getting into the feed, and that's a crime. And so we have to make sure the elk aren't getting into the deer feed.
Wait, so it's a crime to accidentally feed an elk because you intended to feed a deer?
That was the Pennsylvania Game Commission's position. And so the compromise they worked up with the commission was essentially, all right, put some elk excluders around your deer feed. But the point of this is that think of
Put
how
up signs that say this is not for elk, it's just for deer.
Right. The point of this is just think how, I mean, I don't mean to diminish the importance of some of these laws, hunting and wildlife laws, but think about how picayune that is. Like, no one's trying to violate the law here. And yet that kind of suspicion, I guess, justifies placing a camera on somebody's private property without a warrant. And it's not just that they put the camera there and let it be, right? What we found in discovery in the case was that they put the camera there, but then they kept coming back to check on the camera. So we're talking about entry after entry after entry in addition to 24/7 surveillance.
I have a related legal question because when I'm hearing this conversation, I'm reminded frequently of, cats and the reasonable expectation of privacy, which is this sort of odd, balancing factor kind of test that has, lasted for quite a while in the Fourth Amendment space. But one of the tensions it has is with, as technology changes and evolves, it feels like the reasonable expectations of privacy diminish with drones, with cameras. So how do you see the open fields doctrine and the work that we're trying to do here interacting with the reasonable expectation of privacy? Is the end goal to just eliminate that test entirely? Because it does seem a little atextual or certainly non-originalist to have this sort of, reasonable expectation of privacy layer on top of what the Fourth Amendment protects.
I mean, I think that folks have debated cats from all sides of like the kind of judicial philosophy spectrum, right? And I think even among IJers, like folks have like maybe slightly different views of the cats test.
Can I interrupt you for a second? Just for people that maybe aren't lawyers, what is exactly cats and what is this test? Can you explain that?
So I mentioned earlier that in the Hester case, the court was applying kind of strict textualism, right? We're just looking at the words, reading them as narrowly as possible. And cats is a reaction to that. So in 1967, the court says, we're done doing this like hyper literal approach to the Fourth Amendment. Instead, we got to figure out what the Fourth Amendment is all about. And it seems like it's all about privacy, right? And the reason to make that move is actually not a crazy one. It's one that comes from a concern about the impact that technology has on the government's ability to pry into our lives. So historically, the only way the government could learn private things about you that you didn't disclose in the public sphere was to intrude on your property. So historically, privacy and property were bound up in a way that was really hard to disentangle, right? Well, Katz is a 1967 case where the government goes to a public phone booth while a guy's in there and puts a listening device on the booth. So it's an electronic device that can listen to a private conversation that Katz is having in this public phone booth. And the question is Katz's conversation, which is like a private conversation, a person, house, paper, or an effect, right? Because we sort of start to realize that this way of reading the Fourth Amendment is not mapping very well onto new ways the government has to intrude on our lives, right? And so the Katz test, which ultimately comes down to this reasonable expectation of privacy framework you mentioned earlier, does somebody have a reasonable expectation of privacy that the government has intruded on? And how do we figure that out is a tough thing. But that test is designed to kind of accommodate the fact that the government can intrude on our lives in new ways and ways that we can't predict, right? And so to your question about what are we trying to do with open fields in the Katz test, I think what I would say is that the Katz test is probably not going away anytime soon, right? So we have two basic Fourth Amendment frameworks today. We have this reasonable expectation of privacy framework, and we have a framework from the cases I mentioned earlier called Jones and Hardinez that basically says if the government physically trespasses on a person, house, paper, or an effect, that is also subject to Fourth Amendment scrutiny. So either of those is sufficient to trigger the Fourth Amendment now under current law. And I think our position is, like, let's use both of those things to our advantage, right? So let's read the person's, house's, papers, effects language more broadly than we're reading it now and treat the kind of physical trespasses that the government is allowed to do under the open fields doctrine as Fourth Amendment searches. And let's recognize in a common sense way that when people fence their property or post their property consistent with what state law says you have to do to prevent trespassing on your property, right? And it's different in every state. Some states require fencing. Some states say, purple paint is enough, right? So it really varies from state to state. But as long as somebody is doing what the law says you must do, right, in any given state to keep trespassers out, that should be enough to establish that your expectation of privacy on your property is a reasonable one.
So we have I think it's four, right, open fields cases, and they all involve game wardens and, hunting related things. So for people who, don't hunt, who don't have, acres and acres of land, why should they care about the open fields doctrine? How does this affect them?
Well, for one, you might be visiting a property where police have untrammeled authority to surveil you, right? And this is actually I'm not just making this up. It's our clients have expressed this concern where, what they want to do with their property is have guests over, have friends over, have family over, have private moments with those people, right? Whether they're hunting or taking quiet walks or doing anything else on their property. And if they can't guarantee you as a guest that your time will be a private time, you're much less likely to want to come, and they're much less likely to want to invite you there, right? If it's possible that somebody might be spying on you with a camera on my land, you're probably not going to want to come to my land, right? And so just at a kind of common sense level, this affects more than just the owners of the land. But why should we care if we live in like urban areas and we don't want to visit rural areas, right? I think because of a kind of mentality it cultivates in government officials, right? I mentioned earlier, if you give them an inch, they'll take a mile. If you tell government officials that they can treat private property as essentially public, right? That mentality is not going to be limited or cabined to the private land area for too long, right? And we have seen the open fields doctrine kind of mentality creep into other areas that are not just these far-flung rural areas. And I'll just give you a couple examples. In the 80s, there was a kind of line of cases that dealt with aerial surveillance, right? And the issue is the open fields line of cases had to do with the government coming onto your property and visually observing things. And I think what happened in this line of cases about aerial surveillance, planes and helicopters going over people's properties, was that the court sort of said like, oh, if we're not going to protect, visual observation in these other contexts, in these earlier cases, we decided, what's the point of doing it here, right? And so what we get are cases holding that if the government hovers a helicopter over what is admittedly your curtilage, right, in a case called Serralo, that's not going to be considered a Fourth Amendment search, right? There's no constitutional interest at play. And the problem with that, right, is that we can transform helicopters into drones, right? And we can pretty easily see kind of the creep that would come with that. And so imagine a world in which the government can hover a drone over your backyard or over your house. And imagine a world in which that drone has a thermal imaging sensor, right? Imagine a world in which that drone can detect what is going on inside of your house. And if it's true that simply looking at your house from a place the government has a lawful right to be is not a Fourth Amendment search, then we're talking about like a surveillance state at that point, right? And so that mentality, the idea that we can do that kind of surveillance on people in their homes or on their curtilage, I think comes from the premise that the open fields doctrine sets up, was that looking at things is not a search.
And this reminds me a little bit of some of the other areas that we litigate as part of our project on the Fourth Amendment. We've done cases about rental inspections. I know we've done cases with cars. I mean, can you talk a little bit about how the open fields doctrine fits within IJ's broader project on the Fourth Amendment?
Yeah, I mean, the point of the project, it falls under IJ's property rights pillar, and the goal of the pillar is to make sure that people are secure in their property, right? To freely and lawfully use that property to pursue their happiness and build productive lives. And the Fourth Amendment project is part and parcel with that. And so we want to bolster all Americans' right to be secure in their property from unreasonable searches and seizures, right? So we have our U.S. private vaults case, which deals with the kind of surreptitious use of a warrant to invade people's private vaults out in California. We have our rental inspection cases, which deal with the government coming into people's private homes, their rental properties, but their private homes without probable cause to do so, right? We have cases about stops of cars and searches of cars on public roads, which get at this problem called the automobile exception to the warrant requirement, right? Which basically gives the government untrammeled authority to do with you what it will on the side of the road. And so all of these are getting at like Fourth Amendment exceptions or areas where Fourth Amendment law has kind of been weakened to the detriment of people's property rights. And I think our role and our goal with this project is to close all those holes and to bolster the Fourth Amendment so that people in all areas of American life are getting the protection they deserve.
So before we go, the last thing I want to ask you is just what is the sort of principle at the core of all of these, very kind of disparate things that we're doing on the Fourth Amendment? What's sort of the anchor that pulls it all together?
Well, I think it all comes from our insight that the Fourth Amendment starts with the phrase, the people have a right to be secure in their persons, houses, papers, and effects. And that is not an arbitrary word, right? It is a word that connotes not just freedom from invasion, which of course we want to protect, because if you have the kind of privacy that property gives us, right? Having property gives us a sphere that we can control, free from the government's prying eyes and intrusion, right? If you have that kind of privacy, you can build a life. You can pursue your happiness. You can do what Josh Highlander was trying to do when he bought that patch of land 2 houses down from his parents, which is build a house, raise children, do some hunting, take quiet walks, right? His wife works from home, so she's earning a living. Property gives us everything we need to build, with our own little sphere in this world, a life that we value and care about, right? And so part of it is just having the freedom to have that life, right? But it's more than just that. I think part of what security gives us too is the knowledge that the government isn't going to come in anytime, burst through our windows and doors, or spy on us surreptitiously, right? And that's not just a we want the government not to come in problem. It's because I know the government can't come in whenever it wants, I can feel confident that I'm living in a free society. I can feel confident that my choices are mine, my choices are private, my decisions are my own. I can raise my family the way I want to. And so I don't have to tremble inside my castle, right? That's what security gives us.
Thanks for watching today's episode. We had a lot of comments and questions from our last episode about government retaliation. So let's get started. At Vaughn Ellis 7866 writes, in the first case mentioned, I have to wonder if the sheriff is still in office or has he been voted out, as the deputies under him would take their cues from him. Well, that's a great question, Vaughn. Unfortunately, the sheriff and the detective who investigated the case are still employed. At Bugalaman writes, keep up the great work, IJ. Proud to support you. Well, thank you. The Joseph Santos writes, love what you guys do. At Winston Smith writes, the lack of professional bodies enforcing ethical standards is a real problem. Setting aside the obvious lack of morality, most of these abusive power situations should be prevented without resorting to court action. Well, you're absolutely right, Winston. In a perfect world, these abuses of power would be stopped by responsible officials before they happened. But the reason these abuses happen is because it's so difficult to hold officials responsible in the court of law. Qualified immunity breeds complacency, not accountability. At Need Paralegal writes, 42 U.S.C. Section 1983 supersedes qualified immunity. Money damages plus statutory attorney fees. Well, I wholeheartedly agree that Section 1983 supersedes qualified immunity, but the problem is that the Supreme Court doesn't see it that way, despite the statute's plain text and despite ample legislative history. In fact, Professor Alex Reinert at the Cardozo School of Law recently published a piece in the California Law Review pointing out that when Section 1983 was originally enacted, it included a notwithstanding clause that expressly disclaimed immunity doctrines like qualified immunity. That language was inexplicably removed when Congress codified federal statutes for the first time in 1874. But when Congress did so, it was careful to make clear that it was not making substantive changes to the laws it was recodifying. This is strong evidence to suggest that when Congress enacted Section 1983, it wanted the statute to supersede immunities. Unfortunately, when the Supreme Court created qualified immunity nearly a century after Section 1983 was enacted, it neither acknowledged nor engaged with the notwithstanding clause. But that's just another reason for the court to revisit the issue today. At Kermit Wilson writes, didn't the Supreme Court just rule against the Onion on their satire case last year? How does that affect cases like this if they get appealed above the lower court decision? And how could it diminish free speech going forward? Thanks for the question, Kermit. I believe you're referring to Novak versus Parma, an IJ case that involved an Ohio man who was arrested and criminally charged after creating a satirical Facebook page for his local police department. The Sixth Circuit awarded the officers qualified immunity, but the Supreme Court declined to take up his case, despite an absurdly clever amicus brief filed by The Onion, perhaps the most widely recognized satirical publication in the world. Although this was a disappointing outcome for our client in that case, Anthony Novak, the Supreme Court's decision not to take up his case has no bearing on how other appeals courts across the country interpret and apply Section 1983. That means our victory in the Fifth Circuit remains intact, and other appeals courts are free to make similar decisions in their cases. IJ will work hard to make sure that they do just that. At Caroline Kelman 3829 writes, who pays for the $200,000 in damages? Does it come out of the sheriff's personal pockets, or is it taxpayers' money? In theory, the damages are supposed to come out of the officers' pockets. But as UCLA law professor Joanna Schwartz recently pointed out, in practice, officers are almost always indemnified for their conduct. That means that the taxpayer is on the hook for damages, either directly or through the department's insurers hiking their premiums. Do you think that's fair? Let me know in the next comment section and I'll respond next time. As always, thanks for tuning in and for supporting our work here at IJ.